Hello, everyone. We're going to continue with part three of this really long opinion. I have endeavored, with the assistance of these, to find a solution for the grave and difficult question involved in this inquiry. My opinion is that the claim for Congress of supreme power in the territories under the grant to dispose of and make all needful rules and regulations respecting territory is not supported by the historical evidence drawn from the Revolution, the Confederation, or the deliberations which preceded the ratification of the federal Constitution. The Ordinance of 1787 depended upon the action of the Congress of the Confederation, the assent of the state of Virginia, and the acquiescence of the people who recognized the validity of that plea of necessity which supported so many of the acts of the governments of that time. And the federal government accepted the ordinance as a recognized and valid engagement of the Confederation. In referring to the precedents of 1798 and 1800, I find the Constitution was plainly violated by the invasion of the rights of a sovereign state, both of soil and jurisdiction, and in reference to that of 1804. The wisest statesmen protested against it, and the President more than doubted its policy and the power of the government. Mr. John Quincy Adams, at a later period, says of the last act that the President found Congress mounted to the pitch of passing those acts, without inquiring where they acquired the authority, and he conquered his own scruples as they had done theirs. But this court cannot undertake for themselves the same conquest. They acknowledge that our peculiar security is in the possession of a written constitution, and they cannot make it blank paper by construction. They look to its delineation of the operation of the federal government, and they must not exceed the limits it marks out in their administration. The court have said that Congress cannot exercise municipal jurisdiction, sovereignty, or eminent domain within the limits of a state or elsewhere beyond what has been delegated. We are then to find the authority for supreme power in the territories in the Constitution. What are the limits upon the operations of a government invested with legislative, executive, and judicial powers, and charged with the power to dispose of and to make all needful rules and regulations respecting a vast public domain? The feudal system would have recognized the claim made on behalf of the federal government for supreme power over persons and things in the territories. As an incident to this title, that is, the title to dispose of and make rules and regulations respecting it. The Norman lawyers of William the Conqueror would have yielded an implicit assent to the doctrine that a supreme sovereignty is an inseparable incident to a grant to dispose of and to make all needful rules and regulations respecting the public domain. But an American patriot, in contrasting the European and American systems, may affirm that European sovereigns give lands to their colonists, but reserve to themselves a power to control their property, liberty, and privileges. But the American government sells the lands belonging to the people of the several states, i.e., the United States, to their citizens, who are already in the possession of personal and political rights, which the government did not give and cannot take away. And the advocates for government sovereignty in the territories have been compelled to abate a portion of the pretensions originally made in its behalf and to admit that the constitutional prohibitions upon Congress operate in the territories. But a constitutional prohibition is not requisite to ascertain a limitation upon the authority of the several departments of the federal government, nor are the states or people restrained by any enumeration or definition of their rights or liberties. To impair or diminish either, the department must produce an authority from the people themselves in their constitution, and, as we have seen, a power to make rules and regulations respecting the public domain does not confer a municipal sovereignty over persons and things upon it. But as this is thought, therefore, by our adversaries, I propose a more definite examination of it. We have seen Congress does not dispose of or make rules and regulations respecting domain belonging to themselves, but belonging to the United States. These conferred on their mandatory Congress. These conferred on their mandatory Congress authority to dispose of the territory which belonged to them in common, and to accomplish that object beneficially and effectually, they gave an authority to make suitable rules and regulations respecting it. When the power of disposition is fulfilled, the authority to make rules and regulations terminates, for it attaches only upon territory belonging to the United States. Consequently, the power to make rules and regulations from the nature of the subject is restricted to such administrative and conservatory acts as are needful for the preservation of the public domain and its preparation for sale or disposition. The system of land surveys, the reservations for schools, internal improvements, military sites, and public buildings, the preemption claims of settlers, the establishment of land offices and boards of inquiry to determine the validity of land titles, the modes of entry and sale, and of conferring titles, the protection of the lands from trespass and waste, the partition of the public domain into municipal subdivisions having reference to the erection of territorial governments and states, and perhaps the selection under their authority of suitable laws for the protection of the settlers until there may be a sufficient number of them to form a self-sustaining municipal government. These important rules and regulations will sufficiently illustrate the scope and operation of the third section of the fourth article of the Constitution. But this clause in the Constitution does not exhaust the powers of Congress within the territorial subdivisions or over the persons who inhabit them. Congress may exercise there all the powers of government which belong to them as the legislature of the United States, of which these territories make a part. Thus, the laws of taxation for the regulation of foreign, federal, and Indian commerce are so for the abolition of the slave trade, for the protection of copyrights and inventions, for the establishment of postal communication and courts of justice, and for the punishment of crimes, are as operative there as within the states. I admit that to mark the bounds for the jurisdiction of the government of the United States within the territory and of its power in respect to persons and things within the municipal subdivisions it has created is a work of delicacy and difficulty, and, in a great measure, is beyond the cognizance of the judiciary department of that government. How much municipal power may be exercised by the people of the territory. Before their admission to the Union, the courts of justice cannot decide. This must depend for the most part on political considerations, which cannot enter into the determination of a case of law or equity. I do not feel called upon to define the jurisdiction of Congress. It is sufficient for the decision of this case to ascertain whether the residuary sovereignty of the states or people has been invaded by the 8th section of the Act of 6th of March, 1820, I have cited, insofar as it concerns the capacity and status of persons in the condition and circumstances of the plaintiff and his family. These states, at the adoption of the federal constitution, were organized communities having distinct systems of municipal law, which, though derived from a common source and recognizing in the main similar principles, yet in some respects had become unlike on a particular subject promised to be antagonistic. Their systems provided protection for life, liberty, and property among their citizens and for the determination of the condition and capacity of the persons domiciled within their limits. These institutions, for the most part, were placed beyond the control of the federal government. The Constitution allows Congress to coin money and to regulate its value, to regulate foreign and federal commerce, to secure, for a limited period, to authors and inventors a property in their writings and discoveries, and to make rules concerning captures in war, and within the limits of these powers, it has exercised rightly, to a greater or lesser extent, the power to determine what shall and what shall not be property. But the great powers of war and negotiation, finance, postal communication, and commerce in general, when employed in respect to the property of a citizen, refer to and depend upon the municipal laws of the states, to ascertain and determine what is property and the rights of the owner, and the tenure by which it is held. Whatever these constitutions and laws validly determine to be property, it is the duty of the federal government, through the domain of the judiciary, through the domain of jurisdiction merely federal, to recognize to be property. And this principle follows from the structure of the respective governments, state and federal, and their reciprocal relations. They are different agents and trustees of the people of the several states, appointed with different powers and with distinct purposes, but whose acts within the scope of their respective jurisdictions are mutually obligatory. They are respectively the depositories of such powers of legislation as the people were willing to surrender, and their duty is to cooperate within their several jurisdictions to maintain the rights of the same citizens under both governments, unimpaired. A prescription, therefore, of the Constitution and laws of one or more states determining property on the part of the federal government, by which the stability of its social system may be endangered, is plainly repugnant to the conditions on which the federal Constitution was adopted, or or which that government was designed to accomplish. Each of the states surrendered its powers of war and negotiation to raise armies and to support a navy, and all of these powers are sometimes required to preserve a state from disaster and ruin. The federal government was constituted to exercise these powers for the preservation of the states, respectively, and to secure to all their citizens the enjoyment of the rights which were not surrendered to the federal government. The provident care of the statesmen who projected the Constitution was signalized by such a distribution of the powers of government as to exclude many of the motives and opportunities for promoting provocations and spreading discord among the states, and for guarding against those partial combinations so destructive of the community of interest, sentiment, and feeling which are so essential to the support of the Union. The distinguishing features of their system consist in the exclusion of the federal government from the local and internal concerns of, and in the establishment of, an independent internal government within the states. And it is a significant fact in the history of the United States that those controversies which have been productive of the greatest animosity, and have occasioned most peril to the peace of the Union, have had their origin in the well-sustained opinion of a minority among the people, that the federal government had overstepped its constitutional limits to grant some exclusive privilege, or to disturb the legitimate distribution of property or power among the states or individuals. Nor can a more signal instance of this be found than is furnished by the act before us. No candid or rational man can hesitate to believe that if the subject of the 8th section of the Act of March 1820 had never been introduced into Congress and made the basis of legislation, no interest common to the Union would have been seriously affected, and certainly the creation within this Union of large confederacies of unfriendly and frowning states, which has been the tendency and, to an alarming extent, the result, produced by the agitation arising from it, does not commend it to the patriot or statesman. This court have determined that the intermigration of slaves was not committed to the jurisdiction or control of Congress. Wherever a master is entitled to go within the United States, his slave may accompany him without any impediment from or fear of congressional legislation or interference. The question then arises whether Congress, which can exercise no jurisdiction over the relations of master and slave within the limits of the Union, and is bound to recognize and respect the rights and relations that validly exist under the constitutions and laws of the states, can deny the exercise of those rights and prohibit the continuance of those relations within the territories. And the citation of state statutes prohibiting the immigration of slaves and of the decisions of state courts enforcing their forfeiture of the master's title in accordance with their rule only darkens the discussion. For the question is, have Congress the municipal sovereignty in the territories which the state legislatures have derived from the authority of the people and exercise in the states? And this depends upon the construction of the article in the Constitution before referred to, and in my opinion, that clause confers no power upon Congress to dissolve the relations of the master and slave on the domain of the United States, either within or without any of the states. The 8th section of the Act of Congress of the 6th of March, 1820 did not, in my opinion, operate to determine the domestic condition and status of the plaintiff and his family during their sojourn in Minnesota Territory, or after their return to Missouri. The question occurs as to the judgment to be given in this case. It appeared upon the trial that the plaintiff in 1834 was in a state of slavery in Missouri, and he had been in Missouri for near 15 years in that condition when this suit was brought. Nor does it appear that he at any time possessed another state or condition de facto. His claim to freedom depends upon his temporary allocation from the domicile of his origin in company with his master to communities where the law of slavery did not prevail. My examination is confined to the case as it was submitted upon uncontested evidence, upon appropriate issues to the jury, and upon the instructions given and refused by the court upon that evidence. My opinion is that the opinion of the Circuit Court was correct upon all the claims involved in those issues, and that the verdict of the jury was justified by the evidence and instructions. The jury have returned that the plaintiff and his family are slaves. Upon this record, it is apparent that this is not a controversy between citizens of different states, and that the plaintiff, at no period of the life which has been submitted to the view of the court, has had a capacity to maintain a suit in the courts of the United States, and insofar as the argument of the Chief Justice upon the plea in abatement has a reference to the plaintiff or his family in any of the conditions or circumstances of their lives, as presented in the evidence, I concur in that portion of his opinion. I concur in the judgment which expresses the conclusion that the Circuit Court should not have rendered a general judgment. The capacity of the plaintiff to sue is involved in the pleas in bar, and the verdict of the jury discloses an incapacity under the Constitution. Under the Constitution of the United States, his is an incapacity to sue in their courts, while, by the laws of Missouri, the operation of the verdict would be more extensive. I think it a safe conclusion to enforce the lesser disability imposed by the Constitution of the United States, and leave to the plaintiff all his rights in Missouri. I think the judgment should be affirmed on the ground that the Circuit Court had no jurisdiction, or that the case should be reversed and remanded, that the suit may be dismissed. Mr. Justice Ketron, the defendant pleaded to the jurisdiction of the Circuit Court that the plaintiff was an African American of African blood, the descendant of Africans, who had been imported and sold in this country as slaves, and thus had no capacity as a citizen of Missouri to maintain a suit in the Circuit Court. The court sustained a demurrer to this plea, and a trial was had upon the pleas of the general issue, and also that the plaintiff and his family were slaves belonging to the defendant. In this trial, a verdict was given for the defendant. The judgment of the Circuit Court upon the plea in abatement is not open, in my opinion, to examination in this court upon the plaintiff's writ. The judgment was given for him conformably to the prayer of his demurrer. He cannot assign an error in such a judgment, nor does the fact that the judgment was given on a plea to the jurisdiction avoid the application of this rule. The declaration discloses a case within the jurisdiction of the court, a controversy between citizens of different states. The plea in abatement impugning these jurisdictional averments was waived when the defendant answered to the declaration by pleas to the merits. The proceedings on that plea remain a part of the technical record to show the history of the case, but are not open to the review of this court by a writ of error. The authorities are very conclusive on this point. Nor can the court assume as admitted facts the averments of the plea from the confession of the demurrer. That confession was for a single object and cannot be used for any other purpose than to test the validity of the plea. There being nothing in controversy here but the merits, I will proceed to discuss them. The plaintiff claims to have acquired property in himself and became free by being kept in Illinois during 2 years. The Constitution, laws, and policy of Illinois are somewhat peculiar respecting slavery. Unless the master becomes an inhabitant of that state, the slaves he takes there do not acquire their freedom, and if they return with their master to the slave state of his domicile, they cannot assert their freedom after their return. For the reasons and authorities on this point, I refer to the opinion of my brother Nelson, with which I not only concur, but think his opinion is the most conclusive argument on the subject within my knowledge. It is next insisted for the plaintiff that his freedom and that of his wife and eldest child was obtained by force of the Act of Congress of 1820, usually known as the Missouri Compromise Act, which declares that in all that territory ceded by France to the United States, which lies north of 36 degrees 30 minutes north latitude, slavery and involuntary servitude shall be and are hereby forever prohibited. From this prohibition, the territory now constituting the state of Missouri was accepted, which exception to the stipulation gave it the designation of a compromise. The first question presented on this act is whether Congress had power to make such compromise, for if power was wanting, then no freedom could be acquired by the defendant under the act. That Congress had no authority to pass laws and bind men's rights beyond the powers conferred by the Constitution is not open to controversy, but it is insisted that, by the Constitution, Congress has power to delegate for and govern the territories of the United States, and that by force of the power to govern, laws could be enacted prohibiting slavery in any portion of the Louisiana Territory, and, of course, to abolish slavery in all parts of it, whilst it was, or is, governed as a territory. My opinion is that Congress is vested with power to govern the territories of the United States by force of the third section of the fourth article of the Constitution, and I will state my reasons for this opinion. Almost every provision in that instrument has a history that must be understood before the brief and sententious language employed can be comprehended in the relations its authors intended. We must bring before us the state of things presented to the convention, and in regard to which it acted when the compound provision was made, declaring first that new states may be admitted by the Congress into this union. Second, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. Having ascertained the historical facts giving rise to these provisions, the difficulty of arriving at the true meaning of the language employed will be greatly lessened. The history of these facts is substantially as follows. The King of Great Britain, by his proclamation of 1763, virtually claimed that the country west of the mountains had been conquered from France and ceded to the crown of Great Britain by the Treaty of Paris of that year. And he says, "We reserve it under our sovereignty, protection, and dominion for the use of the Indians." This country was conquered from the Crown of Great Britain and surrendered to the United States by the Treaty of Peace of 1783. The colonial charters of Virginia, North Carolina, and Georgia included it. Other states set up pretensions of claim to some portions of the territory north of the Ohio, but they were of no value, as I suppose. As this vacant country had been won by the blood and treasure of all the states, those whose charters did not reach it insisted that the country belonged to the states united and that the lands should be disposed of for the benefit of the whole, and to which end the Western territory should be ceded to the states united. The contest was stringent and angry, long before the convention convened, and deeply agitated that body. As a matter of justice, and to quiet the controversy, Virginia consented to cede the country north of the Ohio as early as 1783, and in 1784 the deed of cession was executed by her delegates in the Congress of the Confederation, conveying to the United States in Congress assembled for the benefit of said states all right, title, and claim, as well of soil as of jurisdiction, which this Commonwealth hath to the territory or tract of country within the limits of the Virginia Charter, situate, lying, and being to the northwest of the River Ohio. In 1787, July 13th, the ordinance was passed by the old Congress to govern the territory. Massachusetts had ceded her pretension of claim to Western Territory in 1785, Connecticut hers in 1786, and New York had ceded hers. In August 1787, South Carolina ceded to the Confederation her pretension of claim to territory west of that state, and North Carolina was expected to cede hers, which she did do in April 1790. And so Georgia was confidently expected to cede her large domain, now constituting the territory of the states of Alabama and Mississippi. At the time of the Constitution was under consideration, there had been ceded to the United States, or was shortly expected to be ceded, all the western country, from the British Canada line to Florida, and from the head of the Mississippi almost to its mouth, except that portion which now constitutes the state of Kentucky. Although Virginia had conferred on the Congress of the Confederation power to govern the territory north of the Ohio, still it cannot be denied, as I think, that power was wanting to admit a new state under the Articles of Confederation. With these facts prominently before the convention, they proposed to accomplish these ends. First, to give power to admit new states. Two, to dispose of the public lands in the territories and such as might remain undisposed of in the new states after they were admitted. And thirdly, to give power to govern the different territories as incipient states, and not of the Union, and fit them for admission. No one in the convention seems to have doubted that these powers were necessary. As early as the third day of its session, May 29th, Edmund Randolph brought forward a set of resolutions containing nearly all the germs of the Constitution, the 10th of which is as follows. Resolved, that the provision ought to be made for the admission of states lawfully arising within the limits of the United States, whether from a voluntary junction of government and territory or otherwise, with the consent of a number of voices in the national legislature less than the whole. August 18th, Mr. Madison submitted, in order to be referred to the Committee of Detail, the following powers as proper to be added to those of the General Legislature: to dispose of the unappropriated lands of the United States, to institute temporary governments for new states arising therein. These, with the resolution that a district for the location of the seat of government should be provided, and some others, were referred, without a dissent, to the Committee of Detail to arrange and put them into satisfactory language. Gouverneur Morris constructed the clauses and combined the views of a majority on the two provisions: to admit new states, and secondly, to dispose of the public lands and to govern the territories in the meantime, between the cessions of the states and the admission into the Union of new states arising in the ceded territory. It was hardly possible to separate the power to make all needful rules and regulations respecting the government of the territory and the disposition of the public lands. North of the Ohio, Virginia conveyed the lands and vested the jurisdiction in the 13 original states before the Constitution was formed. She had the sole title and sole sovereignty, and the same power to cede on any terms she saw proper, and that the King of England had to grant the Virginia Colonial Charter of 1609, or to grant the Charter of Pennsylvania to William Penn. The 13 states, through their representatives and deputed ministers in the old Congress, had the same right to govern that Virginia had before the cession. And the sixth article of the Constitution adopted all engagements entered into by the Congress of the Confederation as valid against the United States, and that the laws made in pursuance of the new Constitution to carry out this engagement should be the supreme law of the land, and the judges bound thereby. To give the compact and the ordinance which was part of it full effect under the new government, to act of the Act of August 7th, 1789, was passed, which declares: whereas, in order that the ordinance of the United States in Congress assembled for the government of the territory northwest of the river Ohio may have full effect, it is requisite that certain provisions should be made so as to adapt the same to the present Constitution of the United States. It is then provided that the governor and other officers should be appointed by the President, with the consent of the Senate, and be subject to removal, in like manner that they were by the old Congress, whose functions had ceased. By the powers to govern given by the Constitution, those amendments to the ordinance could be made, but Congress guardedly abstained from touching the compact of Virginia, further than to adapt it to the new Constitution. It is due to myself to say that it is asking much of a judge who has for nearly 20 years been exercising jurisdiction from the western Missouri line to the Rocky Mountains, and on this understanding of the Constitution, inflicting the extreme penalty of death for crimes committed where the direct legislation of Congress was the only rule, to agree that he had been all the while acting in mistake, and as an usurper. More than 60 years have passed away since Congress has exercised power to govern the territories by its legislation directly, or by territorial charters, subject to repeal at all times, and it is and it is now too late to call that power into question. If this court could disregard its own decision, which it cannot do, as I think, it was held that the case of Cross v. Harrison, that the sovereignty of California was in the power of the United States in virtue of the Constitution, by which power had been given to Congress to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, with the power to admit new states into the Union. That decision followed preceding ones there cited. The question was then presented how it was possible for the judicial mind to conceive that the United States government, created solely by the Constitution, could, by a lawful treaty, acquire territory over which the acquiring power had no jurisdiction to hold and govern it, by force of the instrument under whose authority the country was acquired. And the foregoing was the conclusion of this court on the proposition. What was there announced was most deliberately done and with a purpose. The only question here is, as I think, how far the power of Congress is limited. As to the Northwest Territory, Virginia had the right to abolish slavery there, and she did so agree in 1787 with the other states in the Congress of the Confederation by assenting to and adopting the Ordinance of 1787 for the government of the Northwest Territory. She did this also by an act of her legislature, passed afterwards, which was a treaty in fact. Before the new Constitution was adopted, she had as much right to treat and agree as any European government had. And having excluded slavery, the new government was bound by that engagement by Article 6 of the new Constitution. This only meant that slavery should not exist whilst the United States exercised the power of government in the territorial form, for when a new state came in, it might do so with or without slavery. My opinion is that Congress had no power in face of the compact between Virginia and the 12 other states to force slavery into the Northwest Territory. Because there, it was bound to that engagement and could not break it. In 1790, North Carolina ceded her western territory, now the state of Tennessee, and stipulated that the inhabitants thereof should enjoy all the privileges and advantages of the ordinance for governing the territory north of the Ohio River, and that Congress should assume the government and accept the cession under the express conditions contained in the ordinance, provided that no regulation made or to be made by Congress shall tend to emancipate slaves. In 1802, Georgia ceded her western territory to the United States with the provision that the Ordinance of 1787 should in all its parts extend to the territory ceded, that article only excepted which forbids slavery. Congress had no more power to legislate slavery out from the North Carolina and Georgia cessions than it had power to legislate slavery in north of the Ohio. No power existed in Congress to legislate at all affecting slavery in either case. The inhabitants, as respected this description of property, stood protected whilst they were governed by Congress, in like manner that they were protected before the cession was made, and when they were, respectively, parts of North Carolina and Georgia. And how does the power of Congress stand west of the Mississippi River? The country there was acquired from France by treaty in 1803. It declares that the first consul in the name of the French Republic doth hereby cede to the United States in full sovereignty the colony or province of Louisiana, with all the rights and appurtenances of the said territory, and by Article 3rd, that the inhabitants of the ceded territory shall be incorporated in the Union of the United States and admitted as soon as possible, according to the principles of the federal Constitution, to the enjoyment of all the rights, advantages, and immunities of citizens of the United States, and in the meantime they shall be maintained and protected in the free enjoyment of their liberty, property, and the religion which they profess. Louisiana was a province where slavery was not only lawful, but where property in slaves was the most valuable of all personal property. The province was ceded as a unit with an equal right pertaining to all its inhabitants, in every part thereof, to own slaves. It was, to a great extent, a vacant country, having in it few civilized inhabitants. No one portion of the colony, of a proper size for a state of the Union, had a sufficient number of inhabitants to claim admission into the Union. To enable the United States to fulfill the treaty, additional population was indispensable and obviously desired with anxiety by both sides, so that the whole country should, as soon as possible, become states of the Union. And for this contemplated future population, the treaty as expressly provided as it did for the inhabitants residing in the province when the treaty was made. All these were to be protected in the meantime, that is to say, at all times, between the date of the treaty and the time when the portion of the territory where the inhabitants resided was admitted into the Union as a state. At the date of the treaty, each inhabitant had the right to the free enjoyment of his property, alike with his liberty and his religion, in every part of Louisiana. The province then being one country, he might go elsewhere in it and carry his liberty, property, and religion with him, and in which he was to be maintained and protected until he became a citizen of a state of the Union of the United States. This cannot be denied due to the original inhabitants, and their descendants. And if it be true that immigrants were equally protected, it must follow that they can also stand on the treaty. The settled doctrine in the state courts of Louisiana is that a French subject coming to the Orleans Territory after the Treaty of 1803 was made and before Louisiana was admitted into the Union, and being an inhabitant at the time of the admission, became a citizen of the United States by that act, that he was one of the inhabitants contemplated by the third article of the treaty, which referred to all the inhabitants embraced within the new state on its admission. Uh, that this is the true construction, I have no doubt. If power existed to draw a line at 36 degrees 30 minutes north, so Congress had equal power to draw the line on the 30th degree, that is due west from the city of New Orleans, and to declare that north of that line, slavery should never exist. Suppose this had been done before 1812 when Louisiana came into the Union, and the question of infraction of the treaty had then been presented on the present assumption of power to prohibit slavery. Who doubts what the decision of this court would have been on such an act of Congress? Yet the difference between the supposed line and that on 36 degrees 30 minutes north is only in the degree of grossness presented by the lower line. The Missouri Compromise line of 1820 was very aggressive. It declared that slavery was abolished forever throughout a country reaching from the Mississippi River to the Pacific Ocean, stretching over 32 degrees of longitude and 12.5 degrees of latitude on its eastern side, sweeping over four-fifths, to say no more, of the original province of Louisiana. That the United States government stipulated in favor of the inhabitants to the extent here contended for has not been seriously denied, as far as I know. But the argument is that Congress had authority to repeal the third article of the Treaty of 1803 insofar as it secured the right to hold slave property in a portion of the ceded territory, leaving the right to exist in other parts. In other words, that Congress could repeal the third article entirely at its pleasure. This I deny. The compacts with North Carolina and Georgia were treaties also, and stood on the same footing of the Louisiana Treaty. On the assumption of power to repeal the one, it must have extended to all, and Congress could have excluded the slaveholder of North Carolina from the enjoyment of his lands in the territory now the state of Tennessee, where the citizens of the mother state were the principal proprietors. And so, in the case of Georgia, her citizens could have been refused the right to emigrate to the Mississippi or Alabama territory unless they left their most valuable and cherished property behind them. The Constitution was framed in reference to facts then existing or likely to arise. The instrument looked to no theories of government. In the vigorous debates in the convention, as reported by Mr. Madison and others, surrounding facts and the condition and necessities of the country, gave rise to almost every provision, and among those facts, it was prominently true that Congress dare not be entrusted with power to provide that if North Carolina or Georgia ceded her western territory, the citizens of the state in either case could be prohibited at the pleasure of Congress from removing to their lands, then granted to a large extent in the country likely to be ceded, unless they left their slaves behind. That such an attempt, in the face of a population fresh from the War of the Revolution, and then engaged in war with the great confederacy of Indians, extending from the mouth of the Ohio to the Gulf of Mexico, would end in open revolt, all intelligent men knew. In view of these facts, let us inquire how the question stands by the terms of the Constitution aside from the treaty. How it stood in public opinion when the Georgia cession was made, in 1802, is apparent from the fact that no guarantee was required by Georgia of the United States for the protection of slave property. The federal Constitution was relied on to secure the rights of Georgia and her citizens during the territorial condition of the country. She relied on the indisputable truths that the states were by the Constitution made equals in political rights and equals in the right to participate in the common property for all the states united, and held in trust for them. The Constitution having provided that the citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. The right to enjoy the territory as equals was reserved to the states, and to the citizens of the states respectively. The cited clause is not that citizens of the United States shall have equal privileges in the territories, but the citizen of each state shall come there in right of his state and enjoy the common property. He secures his equality through the equality of his state, by virtue of that great fundamental condition of the Union, the equality of the states. Congress cannot do indirectly what the Constitution prohibits directly. If the slaveholder is prohibited from going to the territory with his slaves, who are parts of his family in name and in fact, it will follow that men owning lawful property in their own states, carrying with them the equality of their state to enjoy the common property, may be told, "You cannot come here with your slaves," and he will be held out at the border. By this subterfuge, owners of slave property to the amount of thousands or of millions might be almost as effectually excluded from removing into their territory of Louisiana, north of 36 degrees 30 minutes, as if the law declared that owners of slaves as a class should be excluded, even if their slaves were left behind. And just as well might Congress have said that those of the North you shall not introduce into the territory south of said line your cattle or horses, as the country is already overstocked. Nor can you introduce your tools of trade or machines, as the policy of Congress is to encourage the culture of sugar and cotton south of the line, and so to provide that the northern people shall manufacture for those of the south, and barter for the staple articles slave labor produces. And thus the northern farmer and mechanic would be held out as the slaveholder was for 30 years by the Missouri restriction. If Congress could prohibit one species of property lawful throughout Louisiana when it was acquired, and lawful in the state from whence it was brought, so Congress might exclude any or all property. The case before us will illustrate the construction contended for. Dr. Emerson was a citizen of Missouri. He had an equal right to go to the territory with every citizen of other states. This is undeniable, as I suppose. Scott was Dr. Emerson's lawful property in Missouri. He carried his Missouri title with him, and the precise question here is whether Congress had the power to annul that title. It is idle to say that if Congress could not defeat the title directly, that it might be done indirectly by drawing a narrow circle around the slave population of Upper Louisiana and declaring that if the slave went beyond it, he should be free. Such assumption is mere evasion and entitled to no consideration, and it is equally idle to contend that because Congress has expressed power to regulate commerce among the Indian tribes and to prohibit intercourse with the Indian tribes, and that therefore Dr. Emerson's title might be defeated within the country ceded by the Indians to the United States as early as 1805, and which embraces Fort Snelling. We must meet the question whether Congress had the power to declare that a citizen of a state, carrying with him his equal rights secured to him through his state, could be stripped of his goods and slaves, and be deprived of any participation in the common property. If this be the true meaning of the Constitution, equality of rights to enjoy a common country equal to 1,000 miles square may be cut off by a geographical line, and a great portion of our citizens excluded from it. Ingenious, indirect evasions of the Constitution have been attempted and defeated heretofore. In the passenger cases, the attempt was made to impose a tax on the masters, crews, and passengers of vessels, the Constitution having prohibited a tax on the vessel itself. But this court held the attempt to be a mere evasion, and pronounced the tax illegal. I admit that Virginia could, and lawfully did, prohibit slavery northwest of the Ohio by her charter of cession, and that the territory was taken by the United States with this condition imposed. I also admit that France could, by the Treaty of 1803, have prohibited slavery in any part of the ceded territory, and imposed it on the United States as a fundamental condition of the cession. In the meantime, till new states were admitted in the Union, I concur with Judge Baldwin that federal power is exercised over all the territory within the United States, pursuant to the Constitution and the conditions of the cession, whether it was a part of the original territory of a state of the Union or of a foreign state, ceded by deed or treaty. The right of the United States in or over it depends on the contract of cession, which operates to incorporate as well the territory as its inhabitants into the Union. My opinion is that the third article of the Treaty of 1803, ceding Louisiana to the United States, stands protected by the Constitution and cannot be repealed by Congress. And secondly, that the Act of 1820, known as the Missouri Compromise, violates the most leading feature of the Constitution, a feature on which the Union depends and which secures to the respective states and their citizens an entire equality of rights, privileges, and immunities. On these grounds, I hold the Compromise Act to have been void, and consequently that the plaintiff Scott can claim no benefit under it. For the reasons above stated, I concur with my brother judges that the plaintiff Scott is a slave and was so when this suit was brought. Judge McLean and Mr. Justice Curtis dissenting. Mr. Justice McLean and Mr. Justice Curtis dissenting. Mr. Justice McLean dissenting. This case is before us on a writ of error from the Circuit Court for the District of Missouri. An action of trespass was brought which charges the defendant with an assault and imprisonment of the plaintiff and also of Harriet Scott, his wife, Eliza and Lizzie, his two children, on the ground that they were his slaves, which was without right on his part and against the law. The defendant filed a plea in abatement that said causes of action, and each and every of them, if any such accrued to the said Dred Scott, accrued out of the jurisdiction of this court and exclusively within the jurisdiction of the courts of the state of Missouri. For that to wit, said plaintiff Dred Scott is not a citizen of the state of Missouri as alleged in his declaration. Because he is an African American of African descent, his ancestors were of pure African blood and were brought into this country and sold as African American slaves. And this the said Sandford is ready to verify. Wherefore he prays judgment whether the court can or will take further cognizance of the action aforesaid. To this, a demurrer was filed, which, on argument, was sustained by the court. The plea in abatement being held insufficient, the defendant was ruled to plead over. Under this rule, he pleaded 1. Not guilty, 2. That Dred Scott was African American slave, the property of the defendant, and 3. That Harriet, the wife, and Eliza and Lizzie, the daughters of the plaintiff, were the lawful slaves of the defendant. The issue was joined on the first plea, and replications of de injuria were filed to the other pleas. The parties agreed to the following facts. In the year 1834, the plaintiff was an African American slave belonging to Dr. Emerson, who was a surgeon in the Army of the United States. In that year, Dr. Emerson took the plaintiff from the state of Missouri to the post of Rock Island in the state of Illinois, and held him there as a slave until the month of April or May 1836. At the time last mentioned, Dr. Emerson removed the plaintiff from Rock Island to the military post at Fort Snelling, situate on the west bank of the Mississippi River in the territory known as Upper Louisiana, acquired by the United States of France. And situate north of latitude 36 degrees 30 minutes north and north of the state of Missouri. Dr. Emerson held the plaintiff in slavery at Fort Snelling from the last mentioned date until the year 1838. In the year 1835, Harriet, who is named in the second count of the plaintiff's declaration, was the African American slave of Major Taliaferro, who belonged to the Army of the United States. In that year, Major Taliaferro took Harriet to Fort Snelling, a military post situated as hereinbefore stated, and kept her there as a slave until the year 1836, and then sold and delivered her as a slave at Fort Snelling unto Dr. Emerson, who held her in slavery at that place until the year 1838. In the year 1836, the plaintiff and Harriet were married at Fort Snelling, with the consent of Dr. Emerson, who claimed to be their master and owner. Eliza and Lizzie, named in the third count of the plaintiff's declaration, are the fruit of that marriage. Eliza is about 14 years old and was born on board the steamboat Gypsy, north of the north line of the state of Missouri and upon the river Mississippi. Lizzie is about 7 years old and was born in the state of Missouri at the military post called Jefferson Barracks. In the year 1838, Dr. Emerson removed the plaintiff and said Harriet and their daughter, Eliza, from Fort Snelling to the state of Missouri, where they have ever since resided. Before the commencement of the suit, Dr. Emerson sold and conveyed the plaintiff, Harriet, Eliza, and Lizzie to the defendant as slaves, and he has ever since claimed to hold them as slaves. At the times mentioned in the plaintiff's declaration, the defendant, claiming to be the owner, laid his hands upon said plaintiff, Harriet, Eliza, and Lizzie, and imprisoned them, doing in this respect, however, no more than he might lawfully do if they were of right his slaves at such times. In the first place, the plea to the jurisdiction is not before us on this writ of error. A demurrer to the plea was sustained, which ruled the plea bad, and the defendant, on leave, pleaded over. The decision on the demurrer was in favor of the plaintiff, and as the plaintiff prosecutes this writ of error, he does not complain of the decision on the demurrer. The defendant might have complained of this decision as against him, and have prosecuted a writ of error to reverse it, but as the case under the instruction of the court to the jury was decided in his favor, of course he had no ground of complaint. But it is said, if the court, on looking at the record, shall clearly perceive that the circuit court had no jurisdiction, it is a ground for the dismissal of the case. This may be characterized as rather a sharp practice, and one which seldom, if ever, occurs. No case was cited in the argument as authority, and not a single case precisely in point is recollected in our reports. The pleadings do not show a want of jurisdiction. This want of jurisdiction can only be ascertained by a judgment on the demurrer to the special plea. No such case, it is believed, can be cited. But if this rule of practice is to be applied in this case, and the plaintiff in error is required to answer and maintain, as well the points ruled in his favor, as to show the error of those ruled against him, he has more than an ordinary duty to perform. Under such circumstances, the want of jurisdiction in the circuit court must be so clear as not to admit of doubt. Now, the plea which raises the question of jurisdiction, in my judgment, is radically defective. The gravamen of the plea is this: that the plaintiff is an African American of African descent, his ancestors being of pure African blood, and were brought into this country and sold as African American slaves. There is no averment in this plea, which shows or conduces to show an inability in the plaintiff to sue in the circuit court. It does not allege that the plaintiff had his domicile in any other state, nor that he is not a free man in Missouri. He is averred to have had an African American ancestry, but this does not show that he is not a citizen of Missouri, within the meaning of the Act of Congress authorizing him to sue in the circuit court. It has never been held necessary to constitute a citizen within the Act that he should have the qualifications of an elector. Females and minors may sue in the federal courts, and so may any individual who has a permanent domicile in the state under whose laws his rights are protected, and to which he owes allegiance. Being born under our Constitution and laws, no naturalization is required, as one of foreign birth, to make him a citizen. The most general and appropriate definition of the term citizen is a freeman. Being a freeman and having his domicile in a state different from that of the defendant, he is a citizen within the Act of Congress, and the courts of the Union are open to him. It has often been held that the jurisdiction as regards parties can only be exercised between citizens of different states, and that a mere residence is not sufficient. But this has been said to distinguish a temporary from a permanent residence. To constitute a good plea to the jurisdiction, it must negative those qualities and rights which enable an individual to sue in the federal courts. This has not been done, and on this ground the plea was defective and the demurrer was properly sustained. No implication can aid a plea in abatement or in bar. It must be complete in itself. The fact stated, if true, must abate or bar the right of the plaintiff to sue. This is not the character of the above plea. The facts stated, if admitted, are not inconsistent with other facts, which may be presumed and which bring the plaintiff within this Act of Congress. The pleader has not the boldness to allege that the plaintiff is a slave, as that would assume against him the matter in controversy and embrace the entire merits of the case in a plea to the jurisdiction. But beyond the facts set out in the plea, the court, to sustain it, must assume the plaintiff to be a slave, which is decisive on the merits. This is a short and an effectual mode of deciding the cause, but I am yet to learn that it is sanctioned by any known rule of pleading. The defendant's counsel complain that if the court take jurisdiction on the ground that the plaintiff is free, the assumption is against the right of the master. This argument is easily answered. In the first place, the plea does not show him to be a slave. It does not follow that a man is not free whose ancestors were slaves. The reports of the Supreme Court of Missouri show that this assumption has many exceptions, and there is no averment in the plea that the plaintiff is not within them. By all the rules of pleading, this is a fatal defect in the plea. If there be doubt, what rule of construction has been established in the slave states? In Jacob v. Sharp, the court held when there was doubt as to the construction of a will which emancipated a slave, it must be construed to be subordinate to the higher and more important right of freedom. No injustice can result to the master from an exercise of jurisdiction in this cause. Such a decision does not in any degree affect the merits of the case. It only enables the plaintiff to assert his claims to freedom before this tribunal. If the jurisdiction be ruled against him on the ground that he is a slave, it is decisive of his fate. It has been argued that if a colored person be made a citizen of a state, he cannot sue in the federal court. The Constitution declares that federal jurisdiction may be exercised between citizens of different states, and the same is provided in the Act of 1789. The above argument is properly met by saying that the Constitution was intended to be a practical instrument, and where its language is too plain to be misunderstood, the argument ends. In Chire v. Chire, this court says that the power of naturalization is exclusively in Congress, does not seem to be, and certainly ought not to be, controverted. No person can legally be made a citizen of a state, and consequently a citizen of the United States, of foreign birth, unless he be naturalized under the acts of Congress. Congress has power to establish a uniform rule of naturalization. It is a power which belongs exclusively to Congress, as intimately connected with our federal relations. A state may authorize foreigners to hold real estate within its jurisdiction, but it has no power to naturalize foreigners and give them the rights of citizens. Such a right is opposed to the acts of Congress on the subject of naturalization and subversive of the federal powers. I regret that any contestants should be given from this bench to a practice like this in some of the states, which has no warrant in the Constitution. In the argument, it was said that a colored citizen would not be an agreeable member of society. This is more a matter of taste than of law. Several of the states have admitted persons of color to the right of suffrage, and in this view have recognized them as citizens, and this has been done in the slave as well as the free states. On the question of citizenship, it must be admitted that we have not been very fastidious. Under the late treaty with Mexico, we have made citizens of all grades, combinations, and colors. The same was done in the admission of Louisiana and Florida. No one ever doubted, and no court ever held, that the people of these territories did not become citizens under the treaty. They have exercised all the rights of citizens without being naturalized under the acts of Congress. There are several important principles involved in this case, which have been argued and which may be considered under the following heads. 1. The locality of slavery as settled by this court and the courts of the states. 2. The relation which the federal government bears to slavery in the states. 3. The power of Congress to establish territorial governments and to prohibit the introduction of slavery therein. 4. The effect of taking slaves into a new state or territory and so holding them where slavery is prohibited. 5. Whether the return of a slave under the control of his master, after being entitled to his freedom, reduces him to his former condition. 6. Are the decisions of the Supreme Court of Missouri on the questions before us binding on this court within the rule adopted? In the course of my judicial duties, I have had occasion to consider and decide several of the above points. 1. As to the locality of slavery, the civil law throughout the continent of Europe, it is believed, without an exception, is that slavery can exist only within the territory where it is established, and that if a slave escapes or is carried beyond such territory, his master cannot reclaim him unless by virtue of some express stipulation. There is no nation in Europe which considers itself bound to return to his master a fugitive slave under the civil law or the law of nations. On the contrary, the slave is held to be free where there is no treaty obligation or compact in some other form to return him to his master. The Roman law did not allow freedom to be sold. An ambassador or any other public functionary could not take a slave to France, Spain, or any other country of Europe without emancipating him. A number of slaves escaped from a Florida plantation and were received on board of ship by Admiral Cochrane. By the King's Bench, they were held to be free. In the great and leading case of Prigg v. the State of Pennsylvania, this court say that by the general law of nations, no nation is bound to recognize the state of slavery as found within its territorial dominions, where it is in opposition to its own policy and institutions in favor of the subjects of other nations where slavery is organized. If it does it, it is as a matter of comity and not as a matter of international right. The state of slavery is deemed to be a mere municipal regulation, founded upon and limited to the range of the territorial laws. This was fully recognized in the Somerset's case, which was decided before the American Revolution. There was some contrariety of opinion among the judges on certain points ruled in Prigg's case, but there was none in regard to the great principle that slavery is limited to the range of the laws under which it is sanctioned. No case in England appears to have been more thoroughly examined than that of Somerset. The judgment pronounced by Lord Mansfield was the judgment of the Court of King's Bench. The cause was argued at great length and with great ability by Hargrave and others who stood among the most eminent counsel in England. It was held under advisement from term to term, and a due sense of its importance was felt and expressed by the bench. In giving the opinion of the court, Lord Mansfield said, the state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law, which preserves its force long after the reasons, occasion, and time itself, from whence it was created, is erased from the memory. It is of a nature that nothing can be suffered to support it but positive law. He referred to the contrary opinion of Lord Hardwicke in October 1749 as Chancellor, that he and Lord Talbot, when Attorney and Solicitor General, were of opinion that no such claim as here presented for freedom was valid. The weight of this decision is sought to be impaired from the terms in which it was described by the exuberant imagination of Curran. The words of Lord Mansfield in giving the opinion of the court were such as were fit to be used by a great judge in a most important case. It is a sufficient answer to all objections to that judgment that it was pronounced before the Revolution, and that it was considered by this court as the highest authority. For near a century, the decision in Somerset's case has remained the law of England. The case of the slave Grace, decided by Lord Stowell in 1827, does not, as has been supposed, overrule the judgment of Lord Mansfield. Lord Stowell held that, during the residence of the slave in England, no dominion, authority, or coercion can be exercised over him. Under another head, I shall have occasion to examine the opinion in the case of Grace. To the position that slavery can only exist except under the authority of law, it is objected that in few, if in any instances, has it been established by statutory enactment. This is no answer to the doctrine laid down by the court. Almost all the principles of the common law had their foundation in usage. Slavery was introduced into the colonies of this country by Great Britain at an early period of their history, and it was protected and cherished until it became incorporated into colonial policy. It is immaterial whether a system of slavery was introduced by express law or otherwise. If it have the authority of law, there is no slave state where the institution is not recognized and protected by statutory enactments and judicial decisions. Slaves are made property by the laws of the slave states, and as such are liable to the claims of creditors. They descend to heirs, are taxed, and in the South they are a subject of commerce. In the case of Rankin v. Lydia, Judge Mills, speaking for the Court of Appeals of Kentucky, says, in deciding the question of slavery, we disclaim the influence of the general principles of liberty, which we all admire, and conceive it ought to be decided by the law as it is, and not as it ought to be. Slavery is sanctioned by the laws of the state, and the right to hold slaves under our municipal regulations is unquestionable. But we view this as a right existing by positive law of a municipal character, without foundation in the law of nature or the unwritten and common law. I will now consider the relation which the federal government bears to slavery in the states. Slavery is emphatically a state institution. In the 9th section of the first article of the Constitution, it is provided that the migration of or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. In the convention, it was proposed by a committee of 11 to limit the importation of slaves to the year 1800, when Mr. Pinckney moved to extend the time to the year 1808. This motion was carried. New Hampshire, Massachusetts, Connecticut, Maryland, North Carolina, South Carolina, and Georgia voting in the affirmative, and New Jersey, Pennsylvania, and Virginia in the negative. In opposition to the motion, Mr. Madison said, 20 years will produce all the mischief that can be apprehended from the liberty to import slaves. So long a term will be more dishonorable to the American character than to say nothing about it in the Constitution. The provision in regard to the slave trade shows clearly that Congress considered slavery a state institution, to be continued and regulated by its individual sovereignty, and to consolidate that interest. The slave trade was continued 20 years, not as a general measure, but for the benefit of such states as shall think proper to encourage it. In the case of Groves v. Slaughter, Clay and Webster contended that under the commercial power, Congress had a right to regulate the slave trade among the several states, but the court held that Congress had no power to interfere with slavery as it exists in the states or to regulate what is called the slave trade among them. If this trade were subject to the commercial power, it would follow that Congress could abolish or establish slavery in every state of the Union. The only connection which the federal government holds with slaves in a state arises from that provision of the Constitution which declares that no person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. This being a fundamental law of the federal government, it rests mainly for its execution, as has been held on the judicial power of the Union, and so far as the rendition of fugitives from labor has become a subject of judicial action, the federal obligation has been faithfully discharged. In the formation of the federal Constitution, care was taken to confer no power on the federal government to interfere with this institution in the states. In the provision respecting the slave trade, in fixing the ratio of representation and providing for the reclamation of fugitives from labor, slaves were referred to as persons, and in no other respect are they considered in the Constitution. We need not refer to the mercenary spirit which introduced the infamous traffic in slaves to show the degradation of African American slavery in our country. This system was imposed upon our colonial settlements by the mother country, and it is due to truth to say that the commercial colonies and states were chiefly engaged in the traffic. But we know as a historical fact that James Madison, that great and good man, a leading member in the Federal Convention, was solicitous to guard the language of that instrument so as not to convey the idea that there could be property in man. I prefer the lights of Madison, Hamilton, and Jay as a means of construing the Constitution in all its bearings, rather than to look behind that period into a traffic which is now declared to be piracy and punished with death by Christian nations. I do not like to draw the sources of our domestic relations from so dark a ground. Our independence was a great epoch in the history of freedom, and while I admit the government was not made especially for the colored race, yet many of them were citizens of the New England states and exercised the rights of suffrage when the Constitution was adopted, and it was not doubted by any intelligent person that its tendencies would greatly ameliorate their condition. Many of the states, on the adoption of the Constitution, or shortly afterward, took measures to abolish slavery within their respective jurisdictions, and it is a well-known fact that a belief was cherished by the leading men, South as well as North, that the institution of slavery would gradually decline until it would become extinct. The increased value of slave labor in the culture of cotton and sugar prevented the realization of this expectation. Like all other communities and states, the South were influenced by what they considered to be their own interests. But if we are to turn our attention to the dark ages of the world, why confine our view to colored slavery? On the same principles, white men were made slaves. All slavery has its origin in power and is against right. The power of Congress to establish territorial governments and to prohibit the introduction of slavery therein is the next point to be considered. After the cession of Western Territory by Virginia and other states to the United States, the public attention was directed to the best mode of disposing of it for the general benefit. While in attendance on the Federal Convention, Mr. Madison, in a letter to Edmund Randolph, dated the 22nd of April, 1787, says, Congress are deliberating on the plan most eligible for disposing of the Western Territory not yet surveyed. Some alteration will probably be made in the ordinance on that subject. And in the same letter, he says, the inhabitants of the Illinois complain of the land jobbers who are purchasing titles among them. Those of St. Vincent's complain of the defective criminal and civil justice among them, as well as of military protection. On the next day, he writes to Mr. Jefferson, the government of the settlements on the Illinois and Wabash is a subject very perplexing in itself, and rendered more so by our ignorance of the many circumstances on which a right judgment depends. The inhabitants at those places claim protection against the savages and some provision for both civil and criminal justice. In May 1787, Mr. Edmund Randolph submitted to the Federal Convention certain propositions as the basis of a federal government, among which was the following. Resolved, that provision ought to be made for the admission of states lawfully arising within the limits of the United States, whether from a voluntary junction of government and territory or otherwise, with the consent of a number of voices in the national legislature less than the whole. Afterward, Mr. Madison submitted to the convention, in order to be referred to the committee of detail, the following powers as proper to be added to those of general legislation: to dispose of the unappropriated lands of the United States, to institute temporary governments for new states arising therein, to regulate affairs with the Indians as well within as without the limits of the United States. Other propositions were made in reference to the same subjects, which it would be tedious to enumerate. Mr. Gouverneur Morris proposed the following: the legislature shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution contained shall be so construed as to prejudice any claims either of the United States or of any particular state. This was adopted as a part of the Constitution, with two verbal alterations. Congress was substituted for legislature, and the word either was stricken out. In the organization of the new government, but little revenue for a series of years was expected from commerce. The public lands were considered as the principal resource of the country for the payment of the revolutionary debt. Direct taxation was a means relied on to pay the current expenses of the government. The short period that occurred between the cession of Western lands to the federal government by Virginia and other states and the adoption of the Constitution was sufficient to show the necessity of a proper land system and a temporary government. This was clearly seen by propositions and remarks in the Federal Convention, some of which are above cited, by the passage of the Ordinance of 1787 and the adoption of that instrument by Congress under the Constitution, which gave to it validity. It will be recollected that the deed of cession of Western Territory was made to the United States by Virginia in 1784, and that it required the territory ceded to be laid out into states, that the land should be disposed of for the common benefit of the states, and that all right, title, and claim, as well of soil as of jurisdiction, were ceded, and this was the form of cession from other states. On the 13th of July, the Ordinance of 1787 was passed for the government of the United States territory northwest of the River Ohio, with but one dissenting vote. This instrument provided there should be organized in the territory not less than 3 nor more than 5 states, designating their boundaries. It was passed while the Federal Convention was in session, about 2 months before the Constitution was adopted by the Convention. The members of the Convention must therefore have been well acquainted with the provisions of the ordinance. It provided for a temporary government as initiatory to the formation of state governments. Slavery was prohibited in the territory. Can anyone suppose that the eminent men of the Federal Convention could have overlooked or neglected a matter so vitally important to the country in the organization of temporary governments for the vast territory northwest of the River Ohio? In the third section of the fourth article of the Constitution, they did make provision for the admission of new states, the sale of the public lands, and the temporary government of the territory. Without a temporary government, new states could not have been formed, nor could the public lands have been sold. If the third section were before us now for consideration for the first time under the facts stated, I could not hesitate to say there was adequate legislative power given in it. The power to make all needful rules and regulations is a power to legislate. This no one will controvert, as Congress cannot make rules and regulations except by legislation. But it is argued that the word territory is used as synonymous with the word land, and that the rules and regulations of Congress are limited to the disposition of lands and other property belonging to the United States. That this is not the true construction of the section appears from the fact that in the first line of the section, the power to dispose of the public lands is given expressly, and in addition, to make all needful rules and regulations. The power to dispose of is complete in itself and requires nothing more. It authorizes Congress to use the proper means within its discretion, and any further provision for this purpose would be a useless verbiage. As a composition, the Constitution is remarkably free from such a charge. In the discussion of the power of Congress to govern a territory in the case of the Atlantic Insurance Company v. Cantor, Chief Justice Marshall, speaking for the court, said, in regard to the people of Florida, they do not, however, participate in political power. They do not share in the government till Florida shall become a state. In the meantime, Florida continues to be a territory of the United States, governed by virtue of that clause in the Constitution which empowers Congress to make all needful rules and regulations respecting the territory or other property belonging to the United States. And he adds, perhaps the power of governing a territory belonging to the United States, which has not, by becoming a state, acquired the means of self-government, may result necessarily from the fact that it is not within the jurisdiction of any particular state and is within the power and jurisdiction of the United States. The right to govern may be the inevitable consequence of the right to acquire territory, whichever may be the source whence the power is derived. The possession of it is unquestioned. And in the close of the opinion, the courts say, in legislating for them the territories, Congress exercises the combined powers of the general and state governments. Some consider the opinion to be loose and inconclusive, others that it is obiter dicta, and that the last sentence is objected. As to recognizing absolute power in Congress over territories, the learned and eloquent Wirt, who, in the argument of a cause before the court, had occasion to cite a few sentences from an opinion of the Chief Justice, observed, no one can mistake the style, the words so completely match the thought. I can see no want of precision in the language of the Chief Justice. His meaning cannot be mistaken. He states first the third section as giving power to Congress to govern the territories, and two other grounds from which the power may also be implied. The objection seems to be that the Chief Justice did not say which of the grounds stated he considered the source of the power. He did not specifically state this, but he did say, whichever may be the source whence the power is derived, the possession of it is unquestioned. No opinion of the court could have been expressed with a stronger emphasis. The power in Congress is unquestioned, but those who have undertaken to criticize the opinion consider it without authority, because the Chief Justice did not designate specially the power. This is a singular objection. If the power be unquestioned, it can be a matter of no importance on which ground it is exercised. The opinion clearly was not obiter dicta. The turning point in the case was whether Congress had power to authorize the territorial legislature of Florida to pass the law under which the territorial court was established, whose decree was brought before this court for revision. The power of Congress, therefore, was the point in issue. The word territory, according to Worcester, means land, country, a district of country under a temporary government. The words territory or other property, as used, do imply, from the use of the pronoun other, that territory was used as descriptive of land, but doesn't follow that it was not used also as a descriptive of a district of country. But does it follow that it was not used also as a descriptive of a district of country? In both of these senses, it belonged to the United States as land for the purpose of sale, as territory for the purpose of government. But if it be admitted that the word territory as used means land and nothing but land, the power of Congress to organize a temporary government is clear. It has power to make all needful regulations respecting the public lands, and the extent of those needful regulations depends upon the direction of Congress, where the means are appropriate to the end and do not conflict with any of the prohibitions of the Constitution. If a temporary government be deemed needful, necessary, requisite, or is wanted, Congress has the power to establish it. This court says in McCulloch v. the State of Maryland, if a certain means to carry into effect any of the powers expressly given by the Constitution to the government of the Union be an appropriate measure, not prohibited by the Constitution, the degree of its necessity is a question of legislative discretion, not of judicial cognizance. The power to establish post offices and post roads gives power to Congress to make contracts for the transportation of the mail, and to punish all who commit depredations upon it in its transit, or at its places of distribution. Congress has power to regulate commerce, and, in the exercise of its discretion, to lay an embargo which suspends commerce, so under the same power, harbors, lighthouses, breakwaters are constructed. The chief did Chief Justice Marshall, in saying that Congress governed a territory by exercising the combined powers of the federal and state governments, refer to unlimited discretion, a government which can make white men slaves? Surely such a remark in the argument must have been inadvertently uttered. On the contrary, there is no power in the Constitution by which Congress can make either white or black men slaves. In organizing the government of a territory, Congress is limited to means appropriate to the attainment of the constitutional object. No power can be exercised which are prohibited by the Constitution, or which are contrary to its spirit, so that whether the object may be the protection of the persons and property of purchasers of the public lands, or of communities who have been annexed by the Union by conquest or purchase, they are initiatory to the establishment of state governments, and no more power can be claimed or exercised than is necessary to the attainment of the end. This is the limitation of all the federal powers. But Congress has no power to regulate the internal concerns of a state as of a territory, consequently, in providing for the government of a territory. To some extent, the combined powers of the federal and state governments are necessarily exercised. If Congress should deem slaves or free colored persons injurious to the population of a free territory as conducing to lessen the value of the public lands, or on any other ground connected with the public interest, they have the power to prohibit them from becoming settlers in it. This can be sustained on the ground of a sound national policy, which is so clearly shown in our history by practical results that it would seem no considerate individual can question it. And as regards any unfairness of such a policy to our Southern brethren, as urged in the argument, it is only necessary to say that, with 1/4 of the federal population of the Union, they have in the slave states a larger extent of fertile territory than is included in the free states, and it is submitted, if masters of slaves be restricted from bringing them into free territory, that the restriction on the free citizens of non-slave holding states by bringing slaves into free territory is 4 times greater than that complained of by the South. But not only so, some 300,000 or 400,000 holders of slaves, by bringing them into free territory, impose a restriction on 20 millions of the free states. The repugnancy to slavery would probably prevent 50 or 100 freemen from settling in a slave territory, where one slaveholder would be prevented from settling in a free territory. This remark is made in answer to the argument urged that a prohibition of slavery in the free territories is inconsistent with the continuance of the Union. Where a territorial government is established in a slave territory, it has uniformly remained in that condition until the people form a state constitution, the same course where the territory is free. Both parties acting in good faith would be attended with satisfactory results. The sovereignty of the federal government extends to the entire limits of our territory. Should any foreign power invade our jurisdiction, it would be repelled. There is a law of Congress to punish our citizens for crimes committed in districts of country where there is no organized government. Criminals are brought to certain territories or states designated in the law for punishment. Death has been inflicted in Arkansas and in Missouri on individuals for murders committed beyond the limit of any organized territory or state, and no one doubts that such a jurisdiction was rightfully exercised. If there be a right to acquire territory, there necessarily must be an implied power to govern it. When the military force of the Union shall conquer a country, may not Congress provide for the government of such country? This would be an implied power essential to the acquisition of new territory. This power has been exercised without doubt of its constitutionality over territory acquired by conquest and purchase. And when there is a large district of country within the United States and not within any state government, if it be necessary to establish a temporary government to carry out a power expressly vested in Congress as the disposition of the public lands, may not such government be instituted by Congress? How do we read the Constitution? Is it not a practical instrument? In such cases, no implication of a power can arise which is inhibited by the Constitution or which may be against the theory of its construction. As my opinion rests on the third section, these remarks are made as an intimation that the power to establish a temporary government may arise also on the other two grounds stated in the opinion of the court in the insurance case. Without weakening the third section. I would here simply remark that the Constitution was formed for our whole country. An expansion or contraction of our territory required no change in the fundamental law when we consider the men who laid the foundation of our government and carried it into operation, the men who occupied the bench, who filled the halls of legislation and the chief magistracy. It would seem, if any question could be settled clear of all doubt, it was the power of Congress to establish territorial governments. Slavery was prohibited in the entire Northwestern Territory with the approbation of leading men, South and North, but this prohibition was not retained when this ordinance was adopted for the government of Southern Territories, where slavery existed. In a late republication of a letter of Mr. Madison, dated November 27, 1819, speaking of this power of Congress to prohibit slavery in a territory, he infers there is no such power from the fact that it has not been exercised. This is not a very satisfactory argument against any power, as there are but few, if any, subjects on which the constitutional powers of Congress are exhausted. It is true, as Mr. Madison states, that Congress, in the act to establish a government in the Mississippi Territory, prohibited the importation of slaves into it from foreign parts, but it is equally true that in the act erecting Louisiana into two territories, Congress declared, "It shall not be lawful for any person to bring into Orleans Territory from any port or place within the limits of the United States any slave which shall have been imported since 1798, or which may hereafter be imported, except by a citizen of the United States who settles in the territory under the penalty of the freedom of such slave." The inference of Mr. Madison, therefore, against the power of Congress is of no force, as it was founded on a fact supposed which did not exist. It is refreshing to turn to the early incidents of our history and learn wisdom from the acts of the great men who have gone to their account. I refer to a report in the House of Representatives by John Randolph of Roanoke as chairman of a committee in March 1803, 54 years ago. From the convention held at Vincennes in Indiana by their president, and from the people of the territory, a petition was presented to Congress praying the suspension of the provision which prohibited slavery in that territory. The report stated that the rapid population of the state of Ohio sufficiently evinces, in the opinion of your committee, that the labor of slaves is not necessary to promote the growth and settlement of colonies in that region. That this labor, demonstrably the dearest of any, can only be employed to advantage in the cultivation of products more valuable than any known to that quarter of the United States. That the committee deem it highly dangerous and inexpedient to impair a provision wisely calculated to promote the happiness and prosperity of the northwestern country, and to give strength and security to that extensive frontier. In the salutary operation of this sagacious and benevolent restraint, it is believed that the inhabitants will, at no very distant day, find ample remuneration for a temporary privation of labor and of emigration. The judicial mind of this country, state, and federal has agreed on no subject, within its legitimate action, with equal unanimity, as on the power of Congress to establish territorial governments. No court, state or federal, no judge or statesman is known to have had any doubts on this question for nearly 60 years after the power was exercised. Such governments have been established from the sources of the Ohio to the Gulf of Mexico, extending to the lakes on the north of the Pacific Ocean on the west, and from the lines of Georgia to Texas. Great interests have grown up under the territorial laws over a country more than 5 times greater in extent than the original 13 states, and these interests, corporate or otherwise, have been cherished and consolidated by a benign policy, without any one supposing the law-making power had united with the judiciary under the universal sanction of the whole country, to usurp a jurisdiction which did not belong to them. Such a discovery at this late date is more extraordinary than anything which has occurred in the judicial history of this or any other country. Texas, under a previous organization, was admitted as a state, but no state can be admitted into the Union which has not been organized under some form of government. Without temporary governments, our public lands could not have been sold, nor our wilderness reduced to cultivation, and the population protected, nor could our flourishing states, west and south, have been formed. What do the lessons of wisdom and experience teach under such circumstances if the new light, which has so suddenly and unexpectedly burst upon us, be true? Acquiescence. Acquiescence under a settled construction of the Constitution for 60 years, though it may be erroneous, which has secured to the country an advancement and prosperity beyond the power of computation. An act of James Madison, when president, forcibly illustrates this policy. He had made up his opinion that Congress had no power under the Constitution to establish a national bank. In 1815, Congress passed a bill to establish a bank. He vetoed the bill on objections other than constitutional. In his message, he speaks as a wise statesman and chief magistrate as follows. Waiving the question of the constitutional authority of the legislature to establish an incorporated bank as being precluded, in my judgment, by the repeated recognitions under varied circumstances of the validity of such an institution in acts of the legislative, executive, and judicial branches of the government, accompanied by indications in different modes of a concurrence of the general will of the nation. Has this impressive lesson of practical wisdom become lost to the present generation? If the great and fundamental principles of our government are never to be settled, there can be no lasting prosperity. The Constitution will become a floating waif on the billows of popular excitement. The prohibition of slavery north of 36 degrees 30 minutes and of the state of Missouri, contained in the act admitting that state into the Union, was passed by a vote of 134 in the House of Representatives to 42. Before Mr. Monroe signed the act, it was submitted by him to his cabinet, and they held a restriction of slavery in a territory to be within the constitutional powers of Congress. It would be singular if in 1804 Congress had power to prohibit the introduction of slaves in Orleans Territory from any other part of the Union, under the penalty of freedom to the slave, if the same power embodied in the Missouri Compromise could not be exercised in 1820. But this law of Congress, which prohibits slavery north of Missouri and of 36 degrees 30 minutes, is declared to have been null and void by my brethren. And this opinion is founded mainly, as I understand, on the distinction drawn between the Ordinance of 1787 and the Missouri Compromise line. In what does the distinction consist? The ordinance, it is said, was a compact entered into by the Confederated States before the adoption of the Constitution, and that in the cession of territory authority was given to establish a territorial government. It is clear that the ordinance did not go into operation by virtue of the authority of the Confederation, but by reason of its modification and adoption by Congress under the Constitution. It seems to be supposed, in the opinion of the court, that the Articles of Cession placed it on a different footing from territories subsequently acquired. I am unable to perceive the force of this distinction, that the ordinance was intended for the government of the Northwestern Territory and was limited to such territory is admitted. It was extended to Southern territories, with modifications, by acts of Congress, and to some Northern territories. But the ordinance was made valid by the act of Congress, and without such act could have been of no force. Uh, it rested for its validity on the act of Congress, the same, in my opinion, as the Missouri Compromise line. If Congress may establish a territorial government in the exercise of its discretion, it is a clear principle that a court cannot control that discretion. This being the case, I do not see on what ground the act is held to be void. It did not purport to forfeit property or take it for public purposes. It only prohibited slavery, in doing which it followed the Ordinance of 1787. I will now consider the fourth head, which is the effect of taking slaves into a state or territory and so holding them where slavery is prohibited. If the principle laid down in the case of Prigg v. the State of Pennsylvania is to be maintained, and it is certainly to be maintained until overruled, as the law of this court, there can be no difficulty on this point. In that case, the court says, the state of slavery is deemed to be a mere municipal regulation, founded upon and limited to the range of the territorial laws. If this be so, slavery can exist nowhere except under the authority of law, founded on usage having the force of law, or by statutory recognition. And the court further says, it is manifest from this consideration that if the Constitution had not contained the clause requiring the rendition of fugitives from labor, every non-slaveholding state in the Union would have been at liberty to have declared free all runaway slaves coming within its limits, and to have given them entire immunity and protection against the claims of their masters. Now, if a slave abscond, he may be reclaimed. But if he accompany his master into a state or territory where slavery is prohibited, such slave cannot be said to have left the service of his master, where his services were legalized. And if slavery be limited to the range of the territorial laws, how can the slave be coerced to serve in a state or territory not only without the authority of law, but against its express provisions? What gives the master the right to control the will of his slave? The local law, which exists in some form. But where there is no such law, can the master control the will of the slave by force? Where no slavery exists, the presumption, without regard to color, is in favor of freedom. Under such a jurisdiction, may the colored man be levied on as the property of his master by a creditor. On the decease of the master, does the slave descend to his heirs as property? Can the master sell him? Any one or all of these acts may be done to the slave, where he is legally held to service. But where the law does not confer this power, it cannot be exercised. Lord Mansfield held that a slave brought into England was free. Lord Stowell agreed with Lord Mansfield in this respect, and that the slave could not be coerced in England, but on her voluntary return to Antigua, the place of her slave domicile, her former status attached. The law of England did not prohibit slavery, but it did not authorize it. The jurisdiction which prohibits slavery is much stronger in behalf of the slave within it than where it only does not authorize it. By virtue of what law is it that a master may take his slave into free territory and exact from him the duties of a slave? The law of the territory does not sanction it. No authority can be claimed under the Constitution of the United States, or any law of Congress. Will it be said that the slave is taken as property, the same as other property which the master may own? To this I answer, that colored persons are made property by the law of the state, and no such power has been given to Congress. Does the master carry with him the law of the state from which he removes into the territory? And does that enable him to coerce his slave in the territory? Let us test this theory. If this may be done by a master from one slave state, it may be done by a master from every other slave state. This right is supposed to be connected with the person of the master by virtue of the local law. Is it transferable? May it be negotiated as a promissory note or bill of exchange? If it be assigned to a man from a free state, may he coerce the slave by virtue of it? What shall this thing be denominated? Uh, is it personal or real property? Or is it an indefinable fragment of sovereignty which every person carries with him from his late domicile? One thing is certain, that its origin has been very recent, and it is unknown to the laws of any civilized country. A slave is brought to England from one of its islands where slavery was introduced and maintained by the mother country. Although there is no law prohibiting slavery in England, yet there is no law authorizing it, and for near a century, its courts have declared that the slave there is free from the coercion of the master. Lords Mansfield and Stowell agree upon this point, and there is no dissenting authority. There is no other description of property which was not protected in England, brought from one of its slave islands. Does not this show that property in a human being does not arise from nature or from the common law, but, in the language of this court, it is a mere municipal regulation founded upon and limited to the range of the territorial laws? This decision is not a mere argument, but it is the end of the law in regard to the extent of slavery. Until it shall be overturned, it is not a point for argument. It is obligatory on myself and my brethren, and on all judicial tribunals over which this court exercises an appellate power. It is said the territories are common property of the states, and that every man has a right to go there with his property. This is not controverted, but the courts say that a slave is not property beyond the operation of the local law which makes him such. Never was a truth more authoritatively and justly uttered by men. Suppose a master of a slave in a British island owned 1,000,000 of property in England. Would that authorize him to take his slaves with him to England? The Constitution, in express terms, recognizes the status of slavery as founded on the municipal law. No person held to service or labor in one state under the laws thereof, escaping into another shall, now, unless the fugitive escape from the now, unless the fugitive escape from a place where, by the municipal law, he is held to labor, this provision affords no remedy to the master. What can be more conclusive than this? Suppose a slave escape from a territory where slavery is not authorized by law. Can he be reclaimed? In this case, a majority of the court have said that a slave may be taken by his master into a territory of the United States, the same as a horse or any other kind of property. It is true this was said by the court, as also many other things which are of no authority. Nothing that has been said by them which has not a direct bearing on the jurisdiction of the court against which they decided can be considered as authority. I shall certainly not regard it as such. The question of jurisdiction being before the court was decided by them authoritatively, but nothing beyond that question. A slave is not a mere chattel. He bears the impress of his maker, and is amendable to the laws of God and man, and he is destined to an endless existence. Unless this head, I shall chiefly rely on the decisions of the Supreme Courts of the Southern states, and especially of the state of Missouri. Under this head, I shall chiefly rely on the decisions of the Supreme Courts of the Southern states, and especially of the state of Missouri. In the first and second sections of the sixth article of the Constitution of Illinois, it is declared that neither slavery nor involuntary servitude shall hereafter be introduced into this state, otherwise than for the punishment of crimes whereof the party shall have been duly convicted. And in the second section it is declared that any violation of this article shall affect the emancipation of such person from his obligation to service. In Illinois, a right of transit through the state is given the master with his slaves. This is a matter which, as I suppose, belongs exclusively to the state. The Supreme Court of Illinois, in the case of Jarrett v. Jarrett, said, after the conquest of this territory by Virginia, she ceded it to the United States and stipulated that the titles and possessions, rights, and liberties of the French settlers should be guaranteed to them. This, it has been contended, secured them in the possession of those African Americans as slaves, which they held before that time, and that neither Congress nor the Convention had power to deprive them of it, or, in other words, that the ordinance and Constitution should not be so interpreted and understood as applying to such slaves, when it is therein declared that there shall be neither slavery nor involuntary servitude in the Northwest Territory, nor in the state of Illinois, otherwise than in the punishment of crimes. But it was held that those rights could not be thus protected, but must yield to the ordinance and Constitution. The first slave case decided by the Supreme Court of Missouri, contained in the reports, was Winnie v. Whitesides at October term 1824. It appeared that more than 25 years before, the defendant, with her husband, had removed from Carolina to Illinois and brought with them the plaintiff, that they continued to reside in Illinois 3 or 4 years, retaining the plaintiff as a slave, after which they removed to Missouri, taking her with them. The court held that if a slave be detained in Illinois until he be entitled to freedom, the right of the owner does not revive when he finds the African American in a slave state. That when a slave is taken to Illinois by his owner, who takes up his residence there, the slave is entitled to freedom. In the case of Lagrange v. Chouteau, it was decided that the Ordinance of 1787 was intended as a fundamental law for those who may choose to live under it, rather than as a penal statute. That any sort of residence contrived or permitted by the legal owner of the slave, upon the faith of secret trusts or contracts, in order to defeat or evade the ordinance, and thereby introduce slavery de facto, would entitle such slave to freedom. In Julia v. McKinney, it was held where a slave was settled in the state of Illinois, but with an intention on the part of the owner to be removed at some future day, that hiring said slave to a person to labor for 1 or 2 days, and receiving the pay for the hire, the slave is entitled to her freedom under the second section of the 6th article of the Constitution of Illinois. Rachel v. Walker is a case involving, in every particular, the principles of the case before us. Rachel sued for her freedom, and it appeared that she had been brought as a slave in Missouri by Stockton, an officer of the army, taken to Fort Snelling, where he was stationed, and she was retained there as a slave a year. And then Stockton removed to Prairie du Chien, taking Rachel with him as a slave, where he continued to hold her 3 years, and then he took her to the state of Missouri and sold her as a slave. Fort Snelling was admitted to be on the west side of the Mississippi River and north of the state of Missouri in the territory of the United States. That Prairie du Chien was in the Michigan territory. On the east side of the Mississippi River, Walker, the defendant, held Rachel under Stockton. The court said in this case, the officer lived in Missouri Territory at the time he brought the slave. He sent to a slaveholding country and procured her. This was his voluntary act, done without any other reason than that of his convenience, and he and those claiming under him must be holden to abide the consequences of introducing slavery both in Missouri Territory and Michigan, contrary to law, and on that ground Rachel was declared to be entitled to freedom. In answer to the argument that as an officer of the army, the master had a right to take his slave into free territory, the court said no authority of law or the government compelled him to keep the plaintiff there as a slave. Shall it be said that because an officer of the army owns slaves in Virginia, that when, as officer and soldier, he is required to take the command of a fort in the non-slaveholding states or territories, he thereby has a right to take with him as many slaves as will suit his interests or convenience. It surely cannot be law. If this be true, the courts say, then it is also true that the convenience or supposed convenience of the officer repeals, as to him and others who have the same character, the ordinance and the act of 1821 admitting Missouri into the Union, and also the prohibition of the several laws and constitutions of the non-slaveholding states. We'll pause there for now, and as usual, if there's any case you'd like me to read, just drop in the comments. Happy to take a look. Thank you.